The broadcast is now starting. All attendees are in listen-only mode.
Hello, and welcome to the ALCTS webinar on Managing and Implementing License Agreements, Part 1. Before we get started, I just want to make it known we are aware there's a little bit of feedback sound difficulties with myself as the host speaking. However, once we move on to the presenter, the sound issues seem to clear up. So if you can bear with me for these first 3 minutes and then the last few minutes of today's hour, the most important speaker, she sounds good. So today's webinar is the second in our 6-part series on licensing electronic resources to serve the library's mission, and the first in our 2-part sub-series on managing and implementing license agreements. I'm Erin Elzey, a member of the ALCTS Continuing Education Committee, and I'll be your host for today's webinar. Our presenter today is Monica Moore. Monica is an electronic resources librarian at the University of Notre Dame and has been working with licenses and general rights issues for 5 years. She earned her MLIS from Syracuse University in 2008. Monica brings much expertise to today's topic, and we are fortunate to have her with us. A few logistics for today's presentation. All attendees are muted to prevent background noise, and we do not have interactive chat capabilities. You may, however, comment on today's presentation using Twitter. The hashtag is ALCTSCE. We do not monitor the Twitter feed, so if you have questions for Monica, please type them into the question box on your screen. We will have time for Q&A after the presentation. This webinar is being recorded, and you will receive an email with links to the recording and presentation slides shortly after the presentation concludes. And now we'll turn it over to Monica. There will be a slight delay as we change presenters.
Hello? Hi. Okay, I've got the message that everybody can hear me. That's a good, promising start. So welcome and thank you for attending this webinar. And I'll give you a little more background. Again, my name is Monica Moore, and I have been here at the University of Notre Dame for 6 years as an electronic resources librarian. And I've been doing licensing for 5 of those years. So everything that I learned about licensing, I learned here on the job. And also I was very fortunate to work with someone with a lot of expertise. So my focus today will be really on what I've learned about the management and implementation of licenses within my institution. So my experience here, and the focus of this webinar is it's on managing licenses that you've already negotiated, that you're just living with, and also things you might be in the process of negotiating, because I've attended a lot of great webinars and conference sessions about licensing, and a lot of them have to do with negotiation. I've learned a lot, but sometimes we have licenses that we inherit, that we just live with and we have to deal with. So I'm going to be sort of coming at it from that framework, where you've already got one in place, or maybe there's one you could be negotiating. So we'll look at both scenarios there. And really the kind of the purpose of this webinar in the series is that it's thinking about how the terms in your licenses affect your stakeholders in the library and even on campus. So the webinar format itself doesn't exactly allow us to have the type of discussion that we might have in a conference or workshop setting. But I will have a couple of polls for you that we can take, so we can maybe get some different viewpoints that we can talk about or address, or I can address. But please feel free to ask questions. As the moderator said, we can log those questions and I can answer them at the end, or you can certainly contact me after the webinar. So, okay, I'm gonna click here, first slide, and I would like to start my talk today by looking at licensing within the context of resource management and electronic resource management, because that's my background. This is one depiction of the steps involved in print resource management, with very basic concepts: acquire, provide access, administer, provide support, evaluate, monitor. Perhaps you've seen this before. And this is the one that you might be more familiar with. It's part of the NASIG core competencies or reference there. And so this, it's maybe a bit dated, but these were the processes that were new when we shifted from print to E. And again, these may not seem so new to people anymore, but what's interesting to me is where the licensing piece fits within this. So the license term is this process that hangs off of the acquire step. And it's interesting to me now too, from where I am after 5 years, how it's in this context in the life cycle, it's just this one small piece. Yet in my experience, licensing touches upon many of the circles here. And what's in a license agreement affects things like how we provide access, how resources are administered. And I just don't think of it anymore as purely acquisitions. It's understandable, but again, I found that this whole range of activities and tasks associated with licensing go beyond it. There's so much post-acquisition work that I do that relates back to this licensing role. So I tried to take this experience and put it into what I call mindsets, with some way to describe it that might be a little fun. And this is where it might get a little bit interesting for us, hopefully. So what you're going to see now is a little bit of my own personal evolution in this role as someone who does licensing. So I want to start off with the first mindset or frame that I sometimes, we could even think of it as a lens through which I view my licensing work. And I call this the paper pusher. This is the acquisitions mindset, and this is where I started. And it made sense because as an ERL, I was sort of folding it into other things I was doing. And the acquisition mindset frames licensing as a piece of paper. It's an agreement. It's this thing that needs to be processed, like a quote or an invoice, and it's on the way to getting something new. It is a hurdle to be surmounted. Whoops, one second. I have a little chat that I need to take care of here, and I'll be right back with you. Okay, so I apologize. So let me get back to my paper pusher mindset here. So this is when usually when you're starting licensing, it's about acquisitions. It's a hurdle that you have to get past to get your stuff. It's sometimes a bottleneck, and a lot of people feel that way because it slows down the process. But when you're in this mindset, you're thinking a lot about things like that are order related. So ongoing funds or one-time money, how's that reflected in the agreement? If it's a multi-year agreement, have we actually secured ongoing funding? Having a relationship already with the vendor, and do we have an agreement on file? Usually that's a good thing. And if it's through a consortium, that makes it easier. So you're sort of thinking along the lines of, how do I push this piece of paper through so we get our stuff? So it's the initial paper trail, basic information that needs to be understood about the acquisition and how this information is reflected in the licensing documents. For example, if a subject librarian is buying a journal back file and I know they're using one-time money, I have to make sure in the license that that's reflected and that we're not getting tied to a subscription, which means we would have to remember to cancel it since we're only doing a one-off purchase. Or on the flip side of that is that if the order is placed for a subscription but the funding used is not recurring, how does the license handle the term of the agreement? And do we have to remember to cancel it or maybe change the terms? So to sum up, the paper pusher here says, what are we getting? How are we getting it? How are we paying for it? That's that mentality. But licensing tends to just get bigger. It's never a simple thing, as I've learned. And as this information is fleshed out, you begin to evolve your questions into more of a why are we getting this in the first place kind of thing. So what I call the collection mindset. I also sometimes call it the annoying but lovable detective, because you begin to slow the process down, in fact, for people, and sometimes ask what appear to be annoying, simple on the surface questions, such as, well, why are we getting this resource? And what is the intended use of it? Which is very important as the more you read the licenses and start to understand what they allow and don't allow, and who needs to have access to it, and the nature of the thing you're buying, because that matters. Is it a journal? Is it a database, a data set? And how do I begin to map it to traditional library services? So to sum up, the annoying but lovable detective says, why are we getting this and what do we want to be able to do with it? So another mindset or lens we can talk about, I call this the carpenter. So once you know what the anticipated uses are for the resource, you turn your mind to the actual agreement or paperwork, which you can now view differently because you've done sort of this background check, really. And that's when you begin the process of review and interpretation. And I call this the carpenter or the implementation mindset because it's where you start to build the agreement or modify it. And you look at how it's even structured. And you shave a little off here, add a little more there, you tweak it here. And then you make sure it covers what you need to, what you want it to cover. And at this point, your questions, again, they're different. You start asking questions about the uses that the agreement allows, which is slightly different from what you're asking in the collection mindset, which is what, the higher level questions of what we want to do with it. Now you're actually seeing how is that reflected in the agreement, and does it conflict with what I know we want to do? What's not allowed? And then these structural questions again. I'll show an example in a couple slides, but when you're in this kind of carpenter role, you're thinking it's referencing other terms. Does it do that? What are all the pieces here that I need to take care of? Even things such as the content that you're licensing, does it come from a third party? Does it come from an aggregator which has third party content? Or is it coming from a vendor which actually has the rights to the content itself? That can make a difference. So, and then even what makes the whole thing binding, what comprises it? How do we make what we want fit what they sent us and how it's signed, sealed, and delivered? And so then this is another mindset. It's not the last one, and I should say that these are not done in order necessarily. I find that I'm in any one of these mindsets at any given point in time, so they're not necessarily sequential. But probably the interpreter here, what I call the management mindset, is where I spend a lot of time because licenses, if licensing is part of your job, it doesn't end after you acquire something. This is what I have learned. You become the keeper of it, of that agreement, of all things related to licensing, or even anything vaguely related to rights issues in your library. So this interpreter management mindset is important because it kind of lives on long after the license is signed. And so at this point, your questions are different. You start thinking about rights to the content, how we use it, what we don't have the right to do, and how do we begin to document that? So we were in that when we were doing the agreement, we knew what we wanted. But how do you document that? And so 6 months later, you can come back to it and communicate to the people who may have questions about it, and push these terms of use out to them. That's a big thing. How do you notify people or communicate about it? And things change over time. And so when you're the interpreter, you have to answer questions that come up maybe years later about what's allowed. Even things like renewals, publishers change. And so what if we need to do something different? We have a lot of things happening now which kind of come under the umbrella of unanticipated uses with some of our resources. And so the interpreter has to go back and read the agreement and actually see, can we do that now? We hadn't thought about negotiating for it at the time. So in summary, the interpreter is saying, how do we communicate rights embodied in the license? How do we communicate the restrictions? And how do we interpret it for new use cases? So since this is a webinar, I can't look out at you. I can't tell if anybody in the audience is nodding at these descriptions and saying, yeah, I think I've been that annoying but lovable detective before. But hopefully some of these, mindset stages, frames, whatever you prefer to call them, maybe, hopefully they resonate with you and you find them helpful. It can also be helpful if you try to explain what licensing really means as your job. Sometimes being able to separate it like this has been helpful for me in explaining, why something takes a little bit longer to do than others. So by management now, and I want to just make clear, because that's a pretty big word, it's a broad word, and in the context of my webinar here, I'm sort of defining it into three areas or buckets: the administrative piece of what I do, the mapping, I call mapping agreements and terms to other areas of the library, Today I'm focused more on library services and people in the library and outside the library, but I also do that for collection development stuff. That's probably something that'll be covered in the part 2 of this series, or the third one next week. So I won't really be touching on that. And then the third point here on the slide, this idea of interpretation and communication of license terms and sort of ongoing need to do that. So I lump this all into one word called management. So that's what I mean when I say that. And I'm going to talk about all 3 of these things in my webinar today. And I'm going to start with license administration. So I wouldn't necessarily say this is the easiest part necessarily, but it's one of the few things that you can sit down and almost do this separately from reading an agreement. You can sit down and maybe just with staff, with the right people, and document some of this. It's very helpful to have on hand. It's sort of your housekeeping stuff. So, decisions as basic as where you store your agreements. And that's not an easy one to answer, really. Do you do it electronically, paper copies in a file cabinet? Do you retain them a certain amount of years? These aren't questions that I have had to ever answer on my own. These were processes and policies I inherited or walked into. But if you are thinking about this and taking on this role and you're new, these are really good places to start conversations to have with the appropriate people on your campus. And basic data such as your FTE numbers, because you see that referenced in agreements all the time, especially when it comes to pricing, things like that, and your IP address ranges, knowing that. And that actually information regarding access, and that's one that even could change. Not everything is IP authentication these days, or it is, but it's shifting. So, being clear about how you make things accessible on your secure network, I mean, that's a good thing to just document, get out there right away, and it's in this administration bucket. So on the right side of the screen, again, I sometimes do the, hey, who signs their agreements and audience participation thing. I do not sign our agreements. I do an initial review with them, and I have a weekly standing meeting with our legal counsel here at Notre Dame. Very fortunate to have that opportunity. I know that other institutions function differently, and I was at a much smaller place before, and that wasn't part of my role, but also we had a different type of relationship with legal counsel. So the answers to these questions will certainly vary, but they're things that you should maybe just ask, document somehow, come up with your own workflow. What is the relationship? When can you go talk to your university's attorneys? And if you can, or if there's someone who can provide information, this is great. So institutional policies. Maybe you have a preferred jurisdiction. Maybe you have, as a private institution versus public, you have different stances on things like indemnification or liability limitations. And that's good information to flush out and to have on hand. It makes the review process easier if you already know what your stance is as an institution. So these are I call these administration. And the other thing I lump into this category is the structural thing that I was sort of alluding to earlier. And I can, many times I have gotten something and someone has asked me, like, do you think the license will take a long time? And I never, and by the way, you should probably always hedge when you're asked that question. It seems like a simple agreement. You look at 2 pieces of paper and you think, how could this possibly, this is a quick read. Well, there's a structural piece that I really wasn't aware of that kind of affects the answer to that question, and also affects how you maybe approach the review. And I think the best example I can show you is this little clause here, where you have parties agree to be bound by this agreement. Maybe that's the thing you were sent. And then it references the terms and conditions of use available at this other URL. And you think, oh, wait a minute, I don't have a copy of that. I should get that. And then down here it says product payment terms available at another URL. And you think, okay, number 3, have to go get that. And then you even have a privacy policy. So really what this is saying is that the agreement comprises all these pieces and parts. And so your 2-page agreement suddenly morphs into a multifaceted or multicellular organism. And it's your job to pull all these parts into one place for the review, and for record keeping, really, to keep it all together. And I think this is especially important if you review agreements with your legal counsel, to know how it's structured and to be able to speak to that and understand how it works together. Because especially in the beginning, if I missed something like this, if I missed a reference and I went for a meeting and I didn't have that, referenced website with some additional terms, it was, I wasn't giving the full picture, and we really couldn't complete the review. So I learned very quickly that it was important for me to get everything together and to really look at what comprises the entire agreement. Okay, so I'm going to I tried to make this as interactive as I could and as hopefully fun as I could. So I came up with a little 2-question quiz for us, or really more of a poll that we're gonna take here in a minute. But before I do that, I want to actually bring the question up and let you take a look at this, and very briefly let me just explain it. I never know if people just prefer to read the slide or if it's easier for me to just explain it. Maybe it's too much text, but how many of you have really, the situation, I can't believe I'm the only one that this has happened to, or that it only happens to us, but this is a situation where you have an agreement and you order something on an order form. The order form references this 2008 agreement, and it's very smooth. Everything's, very easy to follow. You place the order with the order form, and a few weeks later, an invoice shows up, and it references different terms on the invoice than the ones on your order form. And so my question to you is, given this situation, what do you do? And so my colleague here is going to launch a poll, and I'll give you a few seconds to think about this and answer the question, and then we'll talk about it. Okay, so great. So I'm seeing pretty good participation rate. Thank you very much. And it's been fun to watch this come in. And I'm interested in your answers, and it's not because there's one right one. I should clarify this, that I really just wanted, I know that this is a situation that we handle differently. And it looks like for the people who say, what invoice, I never see them, I feel your pain. I don't actually see them here either, because I'm not in the department that pays invoices. But the reason why I am actually, I'm someone who would have answered asking the vendor to update the invoice. That's because a process that was created before I took this role on. We had sort of a tighter relationship in our unit, where we came up with a workflow, or that someone else did before I started, that any kind of invoice, the people processing them know to look for any terms, and if they see them, they loop me in. And usually we ask the vendor to point to our terms. So that's what we do. But it required us to be specific about it and do some communication and training, and asking your legal counsel about it as well, because that's, I'm not a lawyer, and I should have said that up front, but I feel like it was obvious. But whether or not this would be binding or be such a big problem if we let that go, I can't answer that. I think it's good asking your legal counsel to see what their stance is on it, because if they don't feel that's necessary, then you don't have to maybe worry about it. But here we do have that process in place, and regardless of it being really a legal thing, I like it because it is a paper trail that I can follow. That it's very difficult sometimes to remember what terms apply to what resource, and these pieces of paper show up sometimes later on, and if they point to terms of use on a website, even if it's not legally binding you to those terms, you might miss the fact that you negotiated some special use for that resource. So I don't know what licensing personality type that makes me, whoever here on the left-hand side, if I'm a Perry Mason or not, but I tend to err on the side of, being very finicky about making the terms on the invoice match what's on the order form and roll up to our agreement. So, okay, so I'm going to go to the second question in my little quiz here. And again, I'm going to give you like a minute or two here to read this one. And I'll also just talk it through as you're reading it and absorbing this. And maybe again, I hope other people have struggled with this. This happens a lot with publishers merging. We have an agreement. We bought something from Publisher A a few years ago, and then Publisher A is bought by Publisher B. And Publisher B eventually sends you a new agreement and says, we now own Publisher A. From now on, you'll do new orders for both types of content, and this new agreement will cover both. And so the question is, okay, that's great. What do you do with this old Publisher A agreement that technically might have old orders or subscriptions kind of hanging off of it? So that's your question. What do you do with the old publisher? And the poll is going to be opened. And I'll give you, again, some time to share your thoughts. Okay, so we're getting some great participation here. Thank you very much. And so and please continue to weigh in, but I'll take a look and probably I need to take a class on survey design, because as I look at this, you're sort of forced to pick one. But really, I would say the 2, 3, and 4 are all very valid options, and they all probably are things that I would do. Probably the first one, file it and move on. We had a 2% response rate for that. And I'm not saying that any of these are wrong per se, but it seems to be, that it would be great if we could do that. I cannot, I can't sort of live with myself with that. I have to sort of poke this bear all the time. And if you don't ask this question, it's not like you're going to get a lot of direction about this too. So if you were actually told don't worry about it and you're okay with that and that works for you, that's fine. Generally what I find is that I have to go out of my way to ask the vendor, okay, how will this work now? And so asking them to tell me what terms now apply to these old subscriptions, and even if they say, oh yeah, your new agreement will cover them, I actually, I make them or ask them or, come up with some solution to sort of formally tie old orders or subscriptions to new terms. So that way I can actually file the old one and move on when I've archived it. But for me, it's very important to be able to keep the terms of use as closely bound to what we're getting as possible. And sometimes in that process, you do have to do the second option, which is I actually will look to see, all right, we have a new agreement and we have an old one. And this is sometimes not tricky, but this is a little bit tedious. Is there anything in the new agreement that is taking away what rights we had under the old one? So that's the other thing I look for too. So it's the paper trail, but it's also to compare and say, hey, we may have negotiated something really important to us in the older agreement. We don't want to lose that. So let's pull this into the new agreement. So yeah, so those are two examples, 2 quizzes. Hopefully, it's always interesting to see where other people are with this. It's my version of a hallway conversation, maybe at a conference. But I think it gives us an idea of all the things that happen with licensing that don't actually have to do with just strictly negotiation. So I'm going to move on to my next slide and into sort of now I'm going to be talking about this idea of mapping license terms to very common library service points. I picked 3 because they're the ones that they're not the big 3 really, but maybe we could think about them as they're so basic to what we do that I find it, you know, when I review a license, that it's very important for me to keep them in mind all the time. And so I'm going to start here with e-reserves. And so electronic reserves, I think it's one of those key services in a library. And so that's why I picked it as one of my examples. And what I've got here on the screen is three sample clauses that I've pulled out of agreements, and to give you a sense of the differences between them. And the reason why I pulled these is that there's always a difference. You know, there's a sense sometimes, I think, when people think of licensing is something allowed. And if it is, that's great, and we move on. But really what happens is the way it's allowed and the way you have to implement it is where a lot of the work is. And until you actually really have to dissect a sentence or two, you don't necessarily appreciate that. So in the first example, you can see this seems pretty straightforward, and it's allowing us to do e-reserves. But it has 2 concepts to be aware of: linking and this idea of local. So links and e-reserves, which is different than posting content, are, I think, pretty common. But that doesn't mean that the people who do the e-reserves are having that as their default workflow. There may be some technology involved with providing a link to an article in an e-reserve system that they need to be aware of or have some training around, and it may not be their default option or workflow. So sometimes there are linking issues with particular resources. In that case, e-reserve staff may think they can just post the content itself. If they had just been told e-reserves are allowed, that would be a very logical thing to think. So in this case, you have to have a conversation with them about what they're actually doing in order to be able to know if this is something you can accept. And even the idea of local here. You know, sometimes I've had meetings with legal counsel where what does one small word mean? And it slipped by me, but luckily he caught it, and we have to have a conversation about that. And many times you have to go back to the vendor and ask for clarification on what they mean as well. So first example seems pretty straightforward. Second example, also if you look at it sort of in isolation, it seems fine because you're allowed to do this. You're allowed to post things in e-reserve. And posting content seems so much easier in some ways. But it has this quantitative restriction on it. So before you agree to something like this, you should probably have a conversation with your library staff to see if they can accommodate it. And generally, I think it's difficult to comply with any specific quantitative requirements such as this. I don't even bother library staff about it. I know enough about their processes and workflows now to know that this would be burdensome for them. So I push back with a vendor when I'm in the negotiation mode on something like this. If I have to live with it, then it becomes a situation where, okay, how do I let staff know that under these circumstances for this content, they have these restrictions, and then we have to go from there. The third example here on the screen is where e-reserves is not allowed at all, and it's a particularly onerous example. I hope you never run across it. I would never recommend agreeing to this, but sometimes you have to live with things. In this scenario, we would have to have, and I in fact have had to have more conversation and dialogue about it with staff, because it is so restrictive that a link won't even work. We have to almost just completely disallow for this particular content type, which I'm not going to name, but people have to be made aware of these individual publisher restrictions, which in fact live within an aggregator. So it's not an obvious thing, because many of the other things in this resource can be put on e-reserves with no problem, with this one exception. So you occasionally get these very weird edge cases that just need to be addressed, and you have to come up with some kind of workflow with your staff. So interlibrary loan, also pretty big service, pretty important for libraries. And again, I've thrown up 3 examples here and walking you through them to show, you know, how each one of them sort of triggers a different set of circumstances or conversations. So the first one, provide interlibrary loans. I mean, that's just a beautiful clause. I never see this. This is something I pulled from an old agreement. And, you know, it's the easiest one, and it does fall into that example of like, hey, it's allowed. We can check it off the list and move on. You know, no special thing we have to do. That's great. It doesn't often work like that. Generally, in the second example, this is where something is allowed, but it's allowed under certain circumstances. That's generally more typical. In this example, it's more complicated. So we see more detail, more description, things like single copies, individual, the phrase hard copy print form related to the words reproduce and distribute. And these words begin to like kind of almost jump out of the page at you after you've been doing this for a while. So in this case, you have to interpret what they're saying. In my interpretation is that to lend an article from a journal covered by this agreement, the library staff have to print out a copy of the article and distributors send that print copy. And so we're printing a copy and dropping in the mail, and that doesn't seem like what most ILL workflows are about. It seems like a very restrictive thing. It could come from an older agreement and, you know, something at the time that was how we functioned. So in this case, again, it's a conversation to have with your ILL staff, and also to be able to tie it to particular journals for them, not just the agreement itself, but what the agreement covers. And the third example is also interesting in a way. It's like the first one. It's allowing for ILL with no onerous restrictions on you know, other institutions making you make sure it's a non-commercial institution, for example, and being able to just do it in general, do interlibrary loan. But what it's pointing you to is, in this case, it's pointing you to the actual copyright law and to something we call CONTU guidelines. So in this case, you still have to assess what your library is doing and the actual, you know, the people doing the work, and make sure that you're in compliance with the law. So it's the same thing. It's you're allowed to do it, but you have to do it in a certain way. And in each example, the way you can do it is different. And how people are working when they actually do their jobs, that's something that it took me a while to really understand the details, because I'm not in the same department as a lot of the people doing the work, and a lot of their work is affected by the license that I'm doing here in my office. So it's, again, another major library service that's impacted by our agreements. Last example has to do with course packs, print course packs. And I don't know, sometimes I think people think print course packs have gone the way of the dodo. I don't know. I mean, I actually found out in a very roundabout way, and in a kind of a scary way, that we still do this on campus, but it does not happen in the library. It's done through another office on campus. And it's still a service that is used, and it requires a specific communication from me to this office and the staff who work there about what parts of our licensed content actually allow for this use. So in the absence of yes, we can do a print course pack for this content because of this agreement, the print course pack staff actually do not use our licensed content. They instead go through their normal rights clearance workflow and pay the appropriate fees for clearance. So the actual benefit of me having this relationship with them is that we've been able to save a lot of money, because they were doing a fantastic job. They were being very conservative about it, but we in fact were paying twice for using content that we didn't have to pay twice for. So I look at this as another thing to just have on your radar when you're negotiating or interpreting, and finding out where these people are on campus who do this or are affected by it. Again, you've got some example clauses here. And this is the thing where sometimes e-reserves and ILL seem to be explicitly addressed that way in agreement. Sometimes the print course pack has to be interpreted, or you have to construe some language. And again, this is where the relationship with your legal counsel being able to help you with this is so key. I think even the third example here, it doesn't say anything about print course packs at all. And in fact, from this agreement, I happen to know it doesn't address ILL or e-reserves. It simply is talking about the purpose of the content being for academic use, and other common library uses. So that's where you might have to make the call in whatever way is appropriate for your institution about whether or not you can do something. Sometimes it's so explicit, it's easy. Other times you have to do a little more thinking about it. And I also want to mention that I pulled these out for the purpose of the webinar, but when you're reviewing the agreement, you're not just looking at these things in isolation, you're also looking at them in relation to other things in the agreement that maybe are referenced. So, something that seems like you have a right here might be modified elsewhere in the agreement, and not to make it more complicated, it's just a little caveat there. Okay, and so go to, and a brief note here, I picked 3 main things, but I also am addressing this idea kind of off to the side here on the left. Other things have cropped up for me over the years that mean that I have to form new relationships, new stakeholders on campus. The alumni office, because that has become a thing for us about who can use things we license. What people want to do with our licensed content has really become interesting. A lot of people wanting to text mine, use APIs to get at the underlying data. Unanticipated uses, people putting together MOOCs or distance education, and then certainly accessibility issues have been on our radar here for the last year or two. Okay, so this slide, we're going to build a little bit on this, and if it's pretty clear that what I'm walking us through is this developing the skill of reading things and translating them to people who really need to know about it, who need to teach you what they're doing so you can effectively represent them. So it isn't just me telling them what we can and can't do, it's understanding what they do and being able to make the agreement work for that. So this slide just is a bit of a summary. I've been talking about library service points, particularly 3 examples in particular, but you can see, this is just sort of a way to look at it higher level. The license terms affect these other areas, and this represents other stakeholders, other departments, other people you might need to form relationships with. Collections people, policies, your IT folks, and even your legal counsel, and then your library administration. Things like confidentiality agreements. And if you see that, we try to support ARL's stance on not agreeing to confidentiality agreements and in supporting transparency. And sometimes that is a policy that comes out more of the administrative department at your library. So there's kind of a relationship there as well. Okay. So I'm going to move us now into sort of something that is an exercise that I've done with people before in a conference, and I've kind of tweaked it for us here today in the webinar. And it's something that I call who needs to know what when, because it gets at this idea of other people needing to know about terms and what they need to know, and even when they need to know it, and so that they can take the appropriate action. So what I'm going to do now is, in the next couple slides, I'm going to go back to the examples of the licensing clauses that I pulled together. And generally, when I've done this, I've thrown up the clause and I've asked people to come up with their ideas of who might I have to talk with when I see this language. Because I can't really do that in this setting, you're going to have to live with my picks or my choices. But certainly, again, you have the opportunity to form some questions around it. And the point of this is, again, it's not that there's a right or wrong answer. It's to begin to develop the skill of translating language that seems straightforward into what's happening in your local culture, your local institution. Basically, who needs to know about what we're agreeing to here. Okay, so I'm just going to take a quick drink of water here, and you can see 4 examples, hopefully on the screen. So, oops, okay, a little bit of an animation issue here, but we'll work with it. So my first example is kind of straightforward. This is something very innocuous looking in the license agreement. This isn't problematic in any way, but when I see it, actually one of the things that could make you think about is, okay, discovery is kind of a big thing. So if we're getting MARC records, then maybe I need to somehow let the people in systems or discovery or whatever we call it, the people who load records in the catalog, know about that with this vendor. Sometimes it's not always obvious that we're getting that in addition to the resource. And then it's actually helpful to know we're not going to be charged for it. And the people who probably would benefit from that would be the people, again, who do the invoices, making sure they know we don't have to, we're not getting charged for this. And so to look for that. So simple sentence, but actually you could see how there are just even 2 examples I have for people who would benefit from knowing that. Let me click again. Okay, so here's my second example. And I apologize. I hope you're seeing. I hope you're seeing all of these on the slide. I just, in case you're not, I'm actually talking about the second box here, which is the licensee shall ensure that applicable researchers return, destroy, or purge all data. And not only that, they have to provide written certification of that destruction. And this is fairly, I don't want to say common, but I see this with data sets in particular, which we seem to be doing more and more of. And in this scenario, there's a whole compliance issue around this. So it really needs to be an explicit communication and relationship, and possibly some procedure we develop. And the people I get involved with are the researchers themselves, but actually I don't do that without involving the subject librarian, and even perhaps a department. So it might be for a college. You know, the business college here does a lot of work with data, and sometimes being able to work with their administrators over there so that they understand these things we're agreeing to, because it's, you know, it's a compliance thing that me, again, in my office, I don't want to sign that and not communicate that to the people who really need to actually take specific action. So I have to think about who needs to know this, what do they need to do, and actually when they need to do it. Okay, the animation again. Okay, so third example here, a very odd one, edge case. But this is for a DVD that we licensed. So we bought a physical DVD before my time. And apparently it came with terms. And so while we bought the physical copy, we could only use it for a set amount of years. And it was a very weird thing. And I stumbled across it, and it involved having some crazy kind of workaround with the circulation folks. So when they're checking it out, they get something in the system that allows them to know that they can't lend it after a certain amount of time because, you know, the term is finished. Even the systems librarians needing to know about that, because they might have to actually build in something like that, or subject librarians too, because, you know, this, if there's any other thing we could possibly buy, you know, or in the future, please don't agree to it. You know, that this is all kind of a weird. This is a weird example in particular, but it's amazing how something like this kicks off meetings that you never thought you'd have to have. Just one simple phrase in a larger agreement. Last one on this slide, this example, this whole idea of walk-in users, which is what we always ask for and negotiate for. But again, a little bit like the ILL and e-reserves, how that happens, sometimes it varies. And so who is doing that in your library? You know, the IT departments, the systems people, maybe your networking departments on campus, how they configure your secure network, your authentication. So that's another kind of a who here, you know, the parties that really need to be involved, or you need to think of when you get this kind of language. And, you know, eventually when you have sort of some standard idea of what they're doing, this gets easier. It's just that when you begin licensing, it's really hard to know what you're doing as that one person. You don't know what everybody else is doing in a library, and you have to go ask. Okay, a few more here, and then I think we're gonna kind of coming up to the hour, and I want to leave some time for questions. So I'm going to just actually talk about the second one that has to do with the breach. And I think this is one that when I see this, I I like to highlight that and look at that and scrutinize it, because there's a lot more around the breach than what is in here. You know, there's a certain time to resolve it, how many days you have, things like that. And this really should involve the technical people you may need to contact, because sometimes you're required to shut off someone's access. You might need to talk to your legal counsel about, okay, what is our procedure? You know, maybe, and you know, it might have to be something very formulaic while you figure out what the problem is. So this is one where when you see that, and you're, especially, like I said, if you're beginning, you know, come up with some kind of policy or procedure around it that everybody, in a few examples here, can weigh in on. And I've got one last example here and a question mark, because I myself am not really sure who needs to know what when in response to this last clause on your slide. This is actually a good thing. This is really something that's allowing us to put stuff into our institutional repository or into another open access repository. So any authors at our institution who publish in the content we're licensing, notwithstanding anything they've agreed to, we can actually populate a repository. And I think that's great. But I have not figured out who I need to get involved in that kind of a discussion and what kind of workflow procedure I put in place for that. I've left a question mark just as something, and again, it's, you know, this is something that comes up where even when I think I know how things sort of work in my library and feel fairly comfortable with what people are doing, to be able to look at clauses and know they're okay to agree to, there's always something that surprises me. So I'm ending with this one. Certainly if people have questions or even suggestions, I'm open to it. But I think I'm going to, we're at 2:52, and I know I've been talking for a while. So this slide, you'll get the slides, that this is just a little bit of a summary. If you're trying to, again, think about all the people on your team, people you need to have relationships with, this is a good slide for that. And I think if it is okay, we've got a few minutes to open it up for questions. And certainly you can feel free, my contact information is here. Feel free to contact me as well after the webinar. I'm happy to help. Again, I'm, you know, not a lawyer, but from my experience, I'm always glad to share my thoughts. So thank you again for attending, and you know, if we have some questions, and the moderators can forward those to me.
Great, thank you, Monica. So as she mentioned, you do have time for some questions. And if you haven't done yet, go ahead and type your question into the question box there on your go-to panel. So the first question we have is about handling terms within the license agreement. The question is, how do you handle terms like the subscriber takes responsibility for all use of the material by authorized users, or this agreement applies to both the subscribers and the authorized users? Is this attendees' understanding that they can't agree to taking responsibility for all actions of thousands of users?
Mm-hmm.
Do you try to strike a line like this?
Yeah, we tried not to. So that first example of we take all responsibility, first you can sort of soften that language there. I think that we have come to a place where we understand. So yes, you can't acknowledge in the agreement. I mean, you know, technically Notre Dame is the licensee, and we're not asking all of our authorized users to sign the agreement, so we really aren't authorizing on their behalf, or we're not signing for them. But we do make a distinction between licensees and the licensor and licensee and the authorized users, but we also will defend our authorized users. I don't know if that's exactly the right word. We understand that we're agreeing to rights on their behalf and restrictions. And so in some sense, we do take responsibility for them. I don't think we actually use language that's that direct and that, I guess harsh is not the word. That's a little bit, we nuance it, let's put it that way. We look to spell out the relationship so that we are understanding that authorized users are going to be using these terms. We undertake to provide access only to authorized users under these terms, to notify them, but we don't actually we don't take on the responsibility for what they do, especially if they are going outside the bounds of the agreement and what the agreement says they can do. Now, I think what happens is that if someone here who's an employee of the institution does something that's in a breach, I mean, I don't think they're completely cut off and they're on their own. I mean, I think they are supported by the Office of General Counsel. And this feels, as I'm saying this, and I hope that this is helping to answer this question, but it's a very wishy-washy thing. And it's partly a language thing that you can soften, okay? But it's also a policy thing and what your institution, how they feel about it, or how they want to support their staff, faculty, and students. I mean, we essentially are taking on risk for the people we know who are going to use the resources that we're licensing. I mean, I think we're aware and have to deal with a certain level of risk that we're comfortable with. And that's very individual for your institution. That's something that you could actually ask about and maybe really get to the bottom of that, how your Office of General Counsel or your legal counsel feels about it. Does that answer the question, or is that helpful? Again, it's hard for me. It does help. Okay. All right. And again, I apologize for hedging a little bit, but I'm not the attorney, so I can't tell you, but I think that's a great one to take to your attorney if you have access to one.
Great, thank you. So we only have time for one more question, and we really only have one more question in the queue, so it works out well. And it's what to do about vendors who ask for a blanket license covering current plus all future products that you might license from them.
So the vendor wants a blanket license for everything you have now and in the future. Well, I don't know. I'm going to think out loud here. I know we're running out of time, but to me, in some ways, we have, I don't know, we have a consortial license for a journal package, and we add a journal from that publisher to it. I suppose that's something at the time we agreed at, future purchases, but somehow that doesn't sound like what they're doing. It sounds like a blanket agreement to me. Sounds like they just they want to actually kind of bind you to terms for future things you don't know that you're buying yet. I think actually you just need to ask what they mean by a blanket agreement. Does that mean, because the other thing that made me think of is it something you can't change, right? Is a blanket agreement where you're not able to negotiate it. They're just take it or leave it. This covers you. So what they're kind of pitching it is this is convenient for you, but you have to take the terms as they are versus going through a review process. That's the other thing that makes me think of it. So I would maybe push back and ask for clarification about what they mean by a blanket agreement. And, just that makes me uncomfortable to agree to things in the future you don't know, unless again, I'm kind of thinking that journal packages we get through consortium, we add a title. We don't get a new agreement for every single title because we have sort of this umbrella agreement, but I don't think that's what they're saying. Hopefully that's helpful. That's just ask for clarification on that one, and certainly don't just go with it without asking any questions.
Okay, great. Thank you, Monica. So that will wrap up all the time we have for today's session. We are so glad that you could all have been with us today. You will soon receive a short online evaluation form, so please take a few minutes to respond to the questions. Your comments are very valuable and do help the ALCTS Continuing Education Committee plan future events. The email will also include links to today's slide and recording, and you now have the opportunity to receive a certificate of attendance. All of that information will also be included in the email. And thank you again to our presenter, Monica Moore. Thanks also to members of the Continuing Education Committee, Joseph Nicholson and Catherine Balick, and to Alana Warren from the ALCTS office. The support they provide make it possible for us to present these webinars. ALCTS has other continuing education events coming up. There are 4 more webinars in our Licensing Electronic Resources to Serve the Library's Mission series, as well as additional webinars through the remainder of 2018. Next week, we will have the second part of Managing and Implementing License Agreements. Please see the ALCTS website to register or to find more information on these. ALCTS also offers web courses, which are 4 to 6 weeks long, as well as 2-day email discussions. Our next e-forum will be on September 18th, discussing writing strategies and tools for staying on track from start to finish. Please check the website for information on upcoming courses and discussions. And again, thank you all for joining us today, and this will conclude our session.